The next case is Cronos Properties Ltd. versus City of Akron Department of Neighborhood Assistance et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument if that applies. You can refer to them as by initials or by terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honor. Good morning, and may it please the court. I'm Jacqueline Corrigan on behalf of the City of Akron, which is the appellant in this matter, and I would like to reserve 3 minutes of my time for rebuttal. Your Honor, this was an administrative appeal to the Common Pleas Court under Revised Code Chapter 2506, where there was one sole issue that the parties were addressing in their briefs to the trial court, and that was whether a Housing Appeals Board ruling was supported by the preponderance of the reliable, substantial, and probative evidence before it. However, the trial court sallied forth and decided instead an issue that the parties did not develop in their briefs, decided that issue erroneously for 2 reasons, and then ordered the Housing Appeals Board to take an action that is not authorized by law, by the Akron City Code, to take. And so under any standard of review, whether de novo or for an abuse of discretion, the city argues that that decision was in error and asks this court to remand this case back to the trial court for consideration of the reliable, the substantial, and the probative evidence that was presented before the Housing Appeals Board, and to decide the issue that the parties actually argued in their briefs. Now, again, there are 2 possible standards of review that could apply to this matter. Because the trial court sallied forth and engaged in a construction of the Akron City ordinances in light of a comment from the housing administrator, questions of law, of course, are reviewed de novo, and this court may fully disagree with the trial court below and change the judgment. Otherwise, generally in administrative appeals, when a court is looking at the reliable, substantial, and probative evidence, it's also reviewed for an abuse of discretion. But the city is arguing that under the party presentation principle, the trial court in this case abused its discretion there, because courts are not supposed to sally forth and decide issues that the parties have not raised themselves. And that is especially when the parties are represented by counsel, as in this case. And that goes all the way back to many cases from the U.S. Supreme Court, and also even this court in Summit Construction, which is cited in our briefs. So that's why this court, even without talking about the party presentation principle in those terms, repeatedly reminds litigants that if they do not argue an issue, or if they do not develop an argument for this court will not decide it. And that goes for trial courts as well. And that goes to, this court reminded civil litigants in the Maxey case, has reminded civil and criminal litigants in Cardone, and I can't even count the number of times that even in criminal cases, this court has refused to notice what's called a plain error on behalf of a litigant when they have not developed that argument themselves, even when they have mentioned plain error in their assignment of error. And the trial court was clearly wrong when it decided to look at whether the Akron City ordinances and the underlying Department of Neighborhood Assistance order in this case was vague, based merely upon a mention in Cronos Properties, the notice of appeal.
Counsel, let me ask you this.
Sure.
I understand your argument, but I was going back just while you were speaking and looking at the trial court's order again. And in one section in the analysis, the trial court does say, she, in bold type, says that 150.03A requires that you include a list of violations, refer to the sections and subsections violated, and then she goes on to the rest of it, other remedial action. She seems to be saying that she doesn't know exactly what he was alleged to have violated, and therefore it's hard for her to make a determination as to whether there is a substantial probative evidence to support the decision. What's your feeling in regard to that?
That was erroneous, Your Honor, for a couple of reasons. First of all, getting to that actual order, the court had included as Exhibit B to its order at the very tail end of the order, a copy, or actual reproduction of the Department of Neighborhood Assistance order in question. And that actually complies with Akron Code because it not only gives the directive in boldface, comply with the below orders, gives a reasonable date by which compliance must be effected, actually lists the specific violations of Akron's code, and then also gives the citation to the exact sections of Akron's code which are in violation. Now, where the trial court got this wrong was that the trial court was basing its interpretation of this Department of Neighborhood Assistance order on a comment, a warning comment, that was issued by Mr. Greger, the housing administrator, during the hearing, when he was saying, essentially, without, to paraphrase him, that if this rodent infestation gets any worse, it could, or even if it persists, it could be a basis for a different finding, which is under 150.15 of Akron City Ordinances, which is basically the repair or demolish portion of the code. But here's another thing. Just like with courts, trial courts are so, administrative agencies speak through their orders, not through the comments that other participants in their hearings make during the hearing. And that's one of the ways that the trial court ruled erroneously about this order, this DNA order being vague. And I use DNA to stand for Department of Neighborhood Assistance because that's quite a bit to say. So the DNA order was clear. The trial court, unfortunately, used Mr. Greger's comments to misconstrue the DNA order when that wasn't the reasoning behind the housing board's decision. And the board itself, if you want to look at the transcript, the transcript reveals that, because if you don't want to look just at the four corners of the board's decision, which is what the trial court should have only looked at, the board members themselves redirected the discussion away from Mr. Greger's comments, said that's not why we're here. Also, counsel for Cronos said that's not why we're here. And also, when a different board member moved to affirm the DNA order, they specifically said it's just the DNA order that we're looking at. We should affirm this because the evidence that we have heard, not the comments by Mr. Greger, which wasn't evidence either, but the evidence before the board reveals that the DNA order was properly issued and should not be modified. So that's where part of where the trial court got that wrong, because the DNA order did comply with Akron City Ordinances, and then the use of Mr. Greger's comments to interpret the order was an abuse of discretion. That's because we have courts and administrative boards that speak just through their entries. So in addition, though, getting to the underlying arguments by Cronos, the ordinances themselves are not vague either. After all, statutes and ordinances are presumed to be valid unless the party actually makes the proper showing that they aren't. So it would be Cronos's burden to bear to demonstrate that Akron's code doesn't give it fair notice of what Akron's expectations are. And I would draw the court's attention to a contrary case where it did find that an ordinance was unclear when applied to a particular landowner who in the village of Seville was keeping ducks when Seville's zoning ordinance prohibits the keeping of poultry, and it wasn't clear in that it as applied to that duck owner who's keeping the ducks as pets, that poultry didn't apply to the ducks. And also, it's very clear in the precedents before this court and in Ohio that just because an order or a code is not excruciatingly detailed in its spec, and it doesn't have to be granularly specific in order to be valid, in order to show somebody what it is that they need to comply with. So extermination of rodents, which is 150.12E, extermination of rodents means exactly what it says, exterminate them all. So that the code is not vague. The trial court's finding that the DNA order was impermissibly vague is erroneous. And then finally, before I went into my rebuttal time, I would like to address that the trial court's order tells the Housing Appeals Board to take an action it cannot take. The Housing Appeals Board is just an administrative agency, an administrative board. It has absolutely no authority in the Akron City Code or in any kind of legal precedent to issue an order to Akron's Department of Neighborhood Assistance. It's not, it lacks that kind of authority. It can affirm, modify, or reverse one of their orders, but it has no power to order inspectors to go back and write the order again, which is exactly what the trial court had ordered the board to do. And unless there are any further questions from the court, I would reserve the remainder of my time for rebuttal.
Any questions?
Thank you.
Thank you.
Good morning, Your Honors. Attorney Michael McGee for Cronos Properties. May it please the court. This case boils down to specificity. Specificity is what is required by the Ohio Constitution and the United States Constitution in a notice of this kind that's issued by a city agency to a property owner. And this notice, we've all seen it, has no specificity at all.
Counsel, before we get into the merits, the argument by the city is that none of this was ever raised. And there's all kind of case law that talks about you don't look at constitutional issues unless they're specifically raised. So how did the court have the ability to just go off on its own and say that this notice and this statute were not specific enough?
So, Your Honor, it was brought up during the original hearing that the notice lacked specificity and did not advise Cronos Properties specifically what they needed to do.
How was that brought up?
The testimony by the witness from Cronos Properties, which, by the way, was me, was that the notice, or, well, number one, that the statute with regard to road improving the property, because there's two sections here, or two ordinances, excuse me. With regard to road improving the property, it just listed the code section and didn't say what needed to be done. And then the witness testified as to how there is no problem with road improving and that the city has not, the testimony from the inspector was not, There was no testimony from the inspector that there was any problem with road improving, like holes in the walls or open windows or missing window screens or things of that nature. So it was really a big discussion on the record. I suppose it's all testimony, including Mr. Greger's statements, by the way, which are not just comments, but they were testimony, because he was a sworn witness at the hearing, and he made comments, which are testimony. Nevertheless, that's what that section about road improving the property was all about. Now, there was also the other section regarding extermination. And I'd like to address some comments from council about the extermination section. So the extermination section does not say...
Before we get to that, I'm sorry,
Yeah,
but
yes.
before we get to that, I'm still not quite understanding. In regard to the testimony of the witness, whether it's you or whoever, it sounds like you were arguing that they were in compliance with 150.10A13, not that it was too vague, because you're like, we did everything that we could do.
The argument was really both. That, number one, it is road and proof. Everything has been done, everything that can be done has been done. And then also, the city has not presented any testimony about anything that's lacking with regard to road improvement.
But doesn't that go to the weight of the evidence?
Well, it would go to the weight of the evidence if the notice had originally stated what was the deficiency in the road improvement, but the notice didn't say it.
Were there any briefs filed prior to the hearing?
Prior to the
Was there
Housing
any-
Appeals Board
yeah,
hearing?
Was there any statements or anything?
No, no.
All right, and then in regard to the court proceeding, the appeal, were there any briefs filed that addressed the issue of whether or not this was vague?
So the notice of appeal, as I mentioned in my brief in this court, did state that quite clearly.
Right.
And then, I don't have those set of briefs in front of me right now, so without refreshing my recollection, I can't say whether that was brought up at all. I don't think it was a main point of argument. I think the city's point here today is that it wasn't brought up enough. They're not saying that it was never brought up, they're just not saying that it was brought up enough. And our contention, it's Cronos' contention, that it was brought up enough. And the court, the common pleas court judge saw that and then found an additional deficiency in the notice by pointing out that Mr. Greger testified about the habitability section, and it was not in the notice at all. Not even the code section on habitability was in the notice. The other two code sections, at least the code sections were mentioned, but not any statements about what was missing. So, and I'd like to make my point on the extermination section. So the extermination section of the code just talks about financial responsibility and who's supposed to pay for pest control. Is it the tenant or is it the property owner? And it does not say exterminate them all, as council has mentioned here today. It just talks about who is responsible and that they have to take care of it. They have to do what's reasonable. Hiring a pest control company who engages, who's licensed to work in the city and engages in the normal practice of pest control is a reasonable thing to do for a property owner that's got mice in the building. Besides, to exterminate them all, it's going to be, this is an 8-unit apartment building. Council in several briefs has called it a ramshackle building. It's not ramshackle, it's an irregular shaped building, that's about it. But it's got 8 apartment units in it, including a basement. And it's not possible to find out if every last mouse, mice are like an inch to 2 inches long, every last mouse has been gone. So the reasonableness of the steps is what the steps are, not necessarily whether every last tiny little mouse has been exterminated.
What were your actual assignments of error for the appeal in the common police court?
I don't think I brought those set of briefs with me, Your Honor.
Okay. But we did have those. Those were made before the court.
Oh, yeah, those were part of the record on appeal.
Okay.
Yes. So, Your Honors, these deficiencies, there's 3 deficiencies in the notice. One is that it doesn't say what steps, what additional steps are missing or need to be taken to road improve the property. Number two, it doesn't say anything about what the property owner, Cronos, has done or failed to do to exterminate mice. As a matter of fact, I pointed this out in my brief in a couple of different places. The testimony from the housing inspector at the Housing Appeals Board hearing was that she's not a pest control expert, and she does not have any recommendations about what could be done, or what additional could be done, or what's been done wrong, or anything like that. So there's no testimony there at all about that. But the notice has to include what the deficiencies are, so that the property owner has the ability to present a defense. So what happens at these Housing Appeals Board hearings is the property owner shows up, and they're just bombarded with a whole bunch of new things that has never been told to them before. They're not in writing. They're not. They may be, hidden in a file somewhere that the city has that they don't disclose. And the property owners just got to do their best, get in front of a fire squad. So-
But that's not what happened here, though. Everything was about rodents and eradicating rodents and code sections involved with rodents, right?
Well, no.
How specific do you need to get?
So, Your Honor, it was a bit of a firing squad. That's my phrase. The notice says road improve the premises. The property owner knows that he's done everything that he can, and the city won't tell him before the hearing what they think he has done or not done that's deficient in regard to road improving the property. So the property owner gets there, and sort of expecting them to say, well, you didn't do this and you didn't do that. They didn't even do that in this particular case. They said, we don't know what you could have done differently. We're not experts in that. You got to take care of it, but they won't tell you what to do. And the property owner says, well, I've done everything that can be done. And they're like, well, that's too bad. That's not enough. It's got to be in the notice, so that the property owner has sufficient notice and can prepare for that hearing. Bring an additional witness, maybe. Bring some additional documents that they might expect to bring.
I was going to ask you a couple things about that. I understand that Akron Pest Services provided a statement, but nobody testified from them, right? There was no live witness there.
That's correct.
Okay.
Yes.
And,
However, it has been past practice from that board to accept what in a regular court might be considered hearsay testimony, like a letter, in lieu of live testimony. So they accepted it, and they do intend to accept those things.
all right. Then also, in regard to the issues that were raised, were there any photos presented by either the landlord or, the owner or the
I don't believe so, Your Honor.
DNA?
I don't believe any photographs of anything. I don't recall any photographs being presented by either side
Okay.
of it in this case.
And then finally, I guess I still go back to, I'm trying to figure out how your argument is vague as opposed to weight of the evidence. Because if we reverse this, you'd still be able to argue that you did everything you could, right?
At the common pleas level, yes. Yes, we would be able to do that. I don't think we'd get another hearing in front of the Housing Appeals Board unless a new notice is issued.
Right.
And frankly, as I pointed out in my brief near the end there, the city can't issue a new notice because they don't have any specifics. They don't have any idea what could have been done or should have been done differently than what the property owner was doing with regard to mice and extermination.
So the onus on the department would be to identify a problem like black mold, for example, and then give a step-by-step process on how the person is supposed to eradicate the mold? And that would be the only proper notice?
No, so a step-by-step instructions is not required, Your Honor. The level of specificity has got to be enough to put a reasonable person on notice as to what the problem is. So saying there's mold in the house, or just citing a code section regarding mold is not enough. But giving a 20-step instruction is too much. So a notice regarding mold should say something along the lines of, there's mold in the attic, or there's black mold, or green mold, or whatever the color is, in the basement, or in apartment number 3. Especially if you've got, for example, a 200-unit apartment complex, and they claim that they found it in one of the units, but they won't tell them which one.
But don't we have that here where there's a code listed under about more specific?
So the notice with regard to rodent-proofing says, rodent-proof the premises where necessary.
Okay.
That's it. That's not sufficient notice for a reasonable person to know what needs to be done. The code section, which
So
is
if
listed
black
there.
mold was in the premises everywhere, would it be sufficient to say, eliminate the black mold from the premises?
No, they would have to say where it's at. If it's everywhere, then they can say everywhere.
So if this said the word everywhere, then it would be sufficient?
No, because the code section lists a whole bunch of things that are typically need to be done. Cover up exterior holes, put weather stripping under the doors, things like that. All those things had been done already. So if the city thinks one of those things perhaps hadn't been done, they need to put that in the notes. Weather stripping missing on apartment A, or weather stripping missing on all doors, all exterior doors. Then the property owner can say, well, okay, at least I know what they're claiming I didn't do. Here's my photographs showing that there's weather stripping on every single exterior door. Or with regard to mold, hey, here's my photographs. You say that there's mold in apartment A. Well, here's a whole bunch of photographs of apartment A, and there's no mold in there. Or I had a mold inspector come into apartment A, and here's his testimony that there is no mold in apartment A. So there's some items where the location is important to require specificity, and then other sections perhaps not. So if there's roof shingles missing on a roof, I suppose depending on how complicated the roof is, if it's just a single-family house and they say there's 10 or more shingles missing on the roof, that's probably sufficient to put the property owner on notice. But if it's a 10-building apartment complex and they say there's 5 shingles missing on one of the buildings, but they don't say apartment, building number 3 or building number 4, that is not specific, because that property owner might want to go to building number 4 and say, oh, here's my photographs of the roof. There are no shingles missing. You are mistaken. I'm going to bring these photos to the hearing.
We have about 40 seconds.
Okay. Well, I think that covers everything that I wanted to cover with the court, Your Honors. And I thank you for your time. We request that the court affirm the decision of the Common Pleas Court. Thank you.
You have 3 minutes.
Thank you, Your Honors. One thing I would like to remind the court of is that this order from the Department of Neighborhood Assistance was not suggesting demolition, was not suggesting that this apartment building be declared uninhabitable by humans. It was only telling Mr. McGee to look at his property and rodent-proof it wherever it was necessary, whether that meant holes, whether that meant, or whatever that meant, okay? The code is not required to get down to the specificity level of how many shingles are missing off a roof. That's not what the overarching law in Ohio or in the United States requires. It only requires that somebody have a reasonable idea of what they're supposed to do, not down to the granular level.
Counsel, when I used to do housing code violations, and then as a judge hearing housing code violations, usually there was a list that would be attached as well that goes into more detail. Was that there never was a list or anything?
I think we would have to clarify as to when the list was generated, because this property has had an extensive record.
I was just going to ask you about the one that says 9/15/22. It says in addition to 9/15/22 as well.
Yes, there have been previous orders on this premises, and those apparently had not yet been addressed, but that's not the subject of our case today. But speaking of the housing department record, those records are public record. It's not like we're hiding the ball from any property owner. Those are public record. They can be requested, and our Department of Neighborhood Assistance is willing to work with property owners so that they know and can have those records of prior inspections, prior orders, and prior expectations.
So there wasn't an itemized list with this particular?
Not with this particular one. The itemized list was rodent-proof the premises where necessary and exterminate the rodents from the premises, with extermination to begin immediately. And extermination does not mean, make reasonable efforts to try to get rid of some mice. It means get rid of them all. That is the ordinary, common definition of exterminate. If you look at it in Merriam-Webster, that's what it says. So you have to get rid of them all. And I would want to clarify something about 151.2, the responsibility of owners and occupants. Section E regarding rodent extermination does not actually,
I hate to interrupt you, but you are out of time, so if you take 15 seconds and briefly conclude, we appreciate it.
okay, I would like you to look at that section, but in the meantime, the city again respectfully asks you to reverse, remand, so that the trial court can look at the reliable, substantial, and probative evidence that was presented to the board. Thank you very much.
The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you the day it's released, and the opinions are posted on the Ohio Supreme Court website. Thank you both for your presentations.
Thank you.